there, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about this little clause or provision that we have in estate plans that is where you reflect your statement of intent or purpose in creating those estate planning documents. The statement of intent or purposes just reflect the reasons that you, as the trust maker, create a trust, and they're special and important to you. So sometimes it's, to provide for an education or to provide for your loved ones. But your intent or purpose for creating the trust, it can also have significant legal ramifications. For this reason, it's often critical that a trust maker express in writing their purpose for creating the trust. There are essentially two different ways of documenting a trust maker's intent. Each have slightly different purposes, and sometimes both are generally called a statement of intent. So I want to talk to you and kind of just go through and examine each of these. Now, before we delve into that, it is interesting to note, I'm going to get a little technical on you, that Section 801 of the Uniform Trust Code specifically requires that a trustee administer a trust in accordance with its terms and purpose. So I want to emphasize the word purpose. The official comment for this section begins by stating this: the section confirms that a primary duty of a trustee is to follow the terms and purposes of the trust and to do so in good faith. Only if the terms of the trust are silent or for some reason invalid on a particular issue does this code govern the trustee's duties. Yet most trust documents are strangely silent when it comes to expressing what the trust maker's purpose for establishing the trust actually was. As a result, many trustees may not understand the trust maker's purpose for creating the trust, and now they have the responsibility of having to administer it. Now, a solution to this dilemma is to include a statement of intent or purpose as a separate provision in the trust document itself. Now, the Uniform Trust Code is a set of model laws based on the common law of trust that are used by many states. Although they're not binding laws, they are influential in the states. Now, not every state uses the Uniform Trust Code, but there is a great many who do. Further, a trust purpose will not only guide the trustee in administering the trust, but it can also determine whether a trust can be modified or terminated by a court. The Uniform Trust Code provides that a trust may be modified with all of the beneficiaries' consents if a court concludes that the modification is not inconsistent with the material purpose of the trust. Now, under the Uniform Trust Code, a trust may be terminated with all of the beneficiaries' consent if a court finds that the continuance of the trust is not necessary to achieve any material purpose of the trust. Now, some possible examples of a trust material purpose are maybe it's to eliminate or reduce estate taxes, maybe to protect the trust accounts and property from beneficiaries' creditors or divorcing spouses. Maybe it's to educate the trust beneficiaries in financial management, or to provide for a disabled beneficiary, and to preserve the family home regardless of the cost so that your family can enjoy it for many generations to come. Now, the material purpose of a trust may vary widely, but the importance of documenting the trust maker's material purpose, that remains pretty constant. Language of intent or purpose in a trust document can also help beneficiaries understand the trust maker's reasons and potentially ease any hard feelings among beneficiaries, particularly if money and property are to be divided unequally, or if one beneficiary is to receive a unique piece of property or a beloved family heirloom. A statement such as, "I leave great-grandma Johnson's wedding band to my eldest daughter," in keeping with the Johnson's family tradition or passing it from the eldest daughter to eldest daughter, might soothe your younger child's hurt feelings if she believes she was passed over simply because maybe she thinks that her older sister is the favorite of the family. So by putting this definition or explanation, it can just help with the emotional aspects of that. Now I want to talk to you about letters of intent that might be written separate from your trust document itself. And while you might know in great detail how you want your estate planning wishes to be carried out, sometimes it's not always wise or necessary to include every detail in the trust document itself. It is often necessary to leave some discretion in the hands of the trustee to provide for some flexibility in administering a trust that may last for many generations. By way of illustration, few people would disagree that in general, members of the general generation have a different point of view on any number of topics than perhaps some millennials. For example, the question, what is necessary for one's health, education, maintenance, or support, would most likely result in very, very different answers from members of two generations. So older people are clearly going to answer that differently than younger generations would. We often expect trustees to answer these types of questions with no guidance or direction about what the trust maker actually meant. Now, on the other hand, your estate planning attorney may hesitate to include too much detail in your trust document for fear of tying the trustee's hands when circumstances and expectations inevitably change over time. Now, this situation is where a letter of intent can be essential. In general, a letter of intent is a non-binding letter from the trust maker to the trustee that guides them in exercising their discretionary powers. A letter of intent should not be on a law firm's form letter that simply repeats time-worn legal phrases that are used in trust documents. That's not what you want. A well-drafted letter of intent will express in plain old English the trust maker's goals or purposes that might be imprudent or puzzling if they were included in the trust document itself. A letter of intent can provide additional guidance to a trustee who is exercising discretion in interpreting concepts such as health, education, maintenance, or support. If, for example, a trust maker's true concern is to ensure that the cruise vacations the family took together continue after the trust maker's death, then they might include a letter of intent as a statement like the following, for example. Cruises have always been a huge part of helping our family stay connected and close and building family relationships. Funding a cruise for all members of my family is something I would do if I were living. Please make generous distributions for these opportunities because they have tremendous benefits in terms of family connectedness. Now, what I just stated to you is a type of direction that can ease a trustee's concerns about whether money was intended to be used in such a way while not binding their hands to make distributions if they otherwise deem it not to be a good decision because of changed circumstances unknown to the trust maker when they actually wrote that letter of intent. Now, letters of intent can also guide a trustee when a trust maker might have concerns about a particular beneficiary but does not want to detail such concerns in the trust document, where they might prove to be embarrassing for their beneficiary and anyone else who reads the trust. For example, if the trust maker is concerned about, their beneficiary's son's gambling addiction, they might include in their letter of intent a statement such as, "Do not give money outright to my son because I worry that he will simply just gamble it all away. I prefer that you make distributions directly to the payee." So that would be an example. As changes in your circumstance occur over time, you should review your estate plan to ensure that it will accurately reflect your wishes. You should also regularly review any statements of intent with your trust document or letters of intent apart from your trust document to ensure that they too accurately communicate your wishes. If you're interested in learning more about including these statements or letters in your estate plan, please give us a call. So I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law, and we are licensed here in Massachusetts and New Hampshire. So please reach out if you need our assistance with letters of intent or any other types of estate planning.